Senator Womack, is there going to be an amendment that you're presenting this morning?
Mr. Harrelson, it's my understanding we have an amendment available if it's the will of the committee. There had been some discussion as to why we were providing the exemption for family members, for cohabitating adults, but not for homosexuals. Again, we had taken language from other states when we compiled this. If the committee wants the bill as is, then we'll do it as is. If the committee would prefer to have those relationship issues apply to both sections, then I'm certainly open to that.
Senator, staff does not have an amendment, just for your information.
If somebody could somebody's going to contact the person who drafted that, is Maurice Reesby, I believe.
Thanks. Let me ask you, if I can, briefly about the majority opinion in the Howard case.
Yes.
Of course, you mentioned that they just struck it down based on separation of powers grounds, right?
Yes, sir.
My understanding that the basis for that, though, is that they just didn't go any further than that. If they determined that it was unconstitutional on that basis, and they just didn't address other issues. Is that right?
The majority opinion did not. The trial court ruled specifically that it did not violate equal protection or right to privacy. There was a concurring opinion by Justice Brown who indicated that they should have explored those issues, and I would point out that no other justice joined him in that concurring opinion.
Now, this was not an, let's see here, I'm looking at the opinion now. Of course, it says at the end of the opinion, because we've ruled that this regulation is unconstitutional on the basis of separation of powers, we don't have to address the other constitutional arguments. That was written by Justice Corbett, is that correct?
On the majority opinion.
Okay, and Frank Poff, my colleague down in Texarkana, looks like joined him in that opinion. And then a third Justice Brown wrote a concurring opinion, which you just referred to, correct?
Yes, sir. And that's why I brought in the Florida case, because even though the Arkansas trial court had ruled that this was clearly constitutional and did not violate those provisions, since our court did not address it, I wanted to go to the highest level of federal court that had addressed the most similar issue. And to my knowledge, that's the Lofton case out of the 11th Circuit.
But now, when you say our court didn't address it, the majority opinion did not address it. The concurring opinion did address the constitutionality, correct?
Which was the opinion of one justice who was not joined by any others. And the trial court ruled otherwise.
Well, according to this opinion, only three justices joined in the opinion, or two, I guess, in the majority, and then the third one wrote this concurring opinion that says, let me read from the first paragraph. Trial court erred in my judgment in not finding equal protection and privacy violations as well. And he wrote to address those two issues and found that this regulation was, in fact, unconstitutional on those two grounds, equal protection and policy.
But again, that was not the ruling of the court. That was in the concurring opinion from Justice Brown that was not of the majority opinion.
All right. Next issue is, you say that this does not affect, I guess, matters of custody and visitation and guardianship. Is that right?
That's correct.
Wouldn't you agree with me, though, and of course we see this in our private law practice every day, that if we take a policy stand, a public policy stand, that homosexuals are going to be disfavored, then it's just a matter of time before trial courts begin ruling that, well, if homosexuals cannot adopt or they cannot become foster parents, then they're disfavored, so that we cannot allow them to have custody of these children. Would you agree with me there?
I would not agree, and I'll tell you why I think there's a difference. Number one, clearly the precedent is, and there's nothing here that affects this, on issues of custody, trial courts have extremely broad latitude in determining what the best interest of the child is. We don't affect that in any way here. But number two, I would distinguish between custody, where typically you have a natural parent involved in that battle one way or the other. Occasionally there are differences, but typically it's one of the natural parents fighting for the custody of that child. I would distinguish that from the issue of foster care, where you have a child through whatever traumatic experience they've been through is being placed in a home that is usually outside of their family scope, or the issue of adoptive care, where you're making a permanent decision and not only placing someone to reside somewhere under the care of somebody, but terminating any relationships they've had with their previous family and adopting them into a new family. I would distinguish both of those from custody, and that's one of the reasons custody is not affected here.
And let me ask you this. The reason I think it's analogous is because the reason we're here today is to determine whether or not it is in the best interest of the child for homosexuals to be able to adopt or be foster parents. Isn't that correct? We're using the best interest of the child standard?
We are setting a public policy that provides restrictions on, among other restrictions that exist, on who can and cannot be. And one of those considerations, I would think, would be what is in the best interest of the child.
And the best interest of the child is also the standard used by circuit courts around the state to determine whether or not parents should have custody or visitation or guardianship over children, right?
That is correct, but there's a difference between what we put in statute and what we leave to the latitude of the court.
Thank you. I have no further questions.
Next on the list for questioning is Ms. Wade, you're recognized.
Thank you, Mr. Chair. On adoption or foster care by gay people.
The only two statutes that I'm familiar with are Mississippi and Florida. I would suspect that there are probably other states that are in the same posture that Arkansas was in prior to last year, where they have other restrictions or regulations, but I have not researched that. I researched the statutes only because that's what we were dealing with, and I wanted to test the constitutionality there.
Any other questions for Senator Womack? Mr. Johnson, recognized for question.
Senator Womack, I noticed you didn't, I don't think the bill defines homosexual. Is that term defined elsewhere in the code?
I believe that it is defined elsewhere in the code. The language that we have is similar to the language that also does not have a definition though out of the Florida code.
So you use the word homosexual, but you don't define it.
We do not define it in this bill.
And my question is, what about if it's somebody who 5 years ago engaged in a homosexual act, but otherwise has been in a heterosexual relationship? Is that a homosexual for purposes of this statute?
Representative Johnson, the way that we conduct our investigations into who is qualified now is essentially we ask those people to make statements or professions on a number of things related to the background, related to the finances. This would add something else that we're placing there. Typically on those other things, unless they are challenged on their qualifications, we're going to accept them on their statement. And I would assume that, I don't assume, I mean, that's how we would do that on this as well.
But the ban is against homosexuals, not against someone who at some point in their life is engaged in a homosexual act, right? So the question would be, are you a homosexual? That would be the question that would be on the information. Just like when you put into a petition for adoption that you have the economic resources to provide for the well-being of the child, you would essentially make a statement there as well that you are or you are not. And how does, on the other restrictions DHS has, how does DHS enforce those restrictions?
Again, you take the person on the evidence that they present, and unless they're challenged, you take it on that statement.
Thank you, Mr. Chairman.
Mr. Parrish, recognized for question.
Senator, am I to understand that simply to get around this, we just simply have to not mark that box if I were a homosexual and I wanted to adopt a child, I just don't mark the box, and then if in fact someone has an idea that I am a homosexual, how will they follow up and how will they prove that?
They would put on evidence for the court to make a determination, just like they would on any other aspect of your qualifications. When you do it in the terms of a petition for adoption, you're essentially making a statement to the court that it's a sworn statement that you're making to the court that the facts that you are putting in there are true and correct.
All right. Well, and I guess, and you may can answer this. How would we propose to that the court investigate that? Do you have any remedy to what the investigation would entail to prove, in fact, that person is a homosexual? I just don't. I guess what I'm caught up on is how in the world we're ever going to. I mean, it's just a simple matter. If people want to adopt a child for what you want to protect them from, which is abuse, they just simply, obviously they're not of high moral character at that point. If that's their purpose for adopting or becoming a foster parent, I doubt they're going to be dissuaded by a box.